So even though the Glock switch itself, clearly not a firearm, under the definition of machine gun, that little thing is in fact a full-blown machine gun.
It is. We are the Arms Attorneys. Today we are actually providing an update to Monday's video about the Hughes Amendment. Could we take down the rule prohibiting new machine guns for civilian ownership? Did we just take that first step in a new case that dropped? We are going to talk through what has happened in the U.S. versus Morgan case, what parts of it are important and what parts of it kind of hold us back a little bit, and finally, what's next. But before we get started, show your support for the Second Amendment by hitting the like button. And I will say for people, and legitimate confusion, so this video that we did about, just hypothetically, and I say we royally because it was, of course, Richard and I.
Yes.
Hypothetically, is the Hughes Amendment the first thing to come out of the NFA? We think so. And that video dropped on Monday, August 26th. And then people are like, well, wasn't there a case a couple days before that video? There was. We batch film videos a lot of times to work around our court schedules and things like that. And so we batch filmed that before U.S. versus Morgan was decided. And then here we are filming another couple right now. So this is coming out as fresh as our daisies get in this office because we have to work around clients. So here we are. This is United States versus Morgan. It is the district court for the District of Kansas. It's case number 23-10047-JWB. We will flash it up here and you should pull it if you are interested. This is a case decided by Judge Brooms.
Yes, and I'm sure that if you're out there Googling this case, every single headline you will find about it will declare in a most alarmist fashion, Trump-appointed judge declares machine gun possession legal.
Right, and this really, we make all sorts of constitutional challenges, right? But you can really throw two, when we're talking about the criminal laws, where you can really throw them into two big buckets, right? Which are facial challenges and as applied challenges. So what is the difference, Edwin, and what is happening here?
Well, a facial challenge is whenever a court looks at a law and says, is this law unconstitutional in every possible application that can be thought about under the sun? And that is the most broad. Whenever a law is declared facially unconstitutional, it's gone.
Gonzo.
It is, nobody has to abide by it. It is thrown away. It is relegated to the dustbin of history. However, in an as-applied challenge, that case is specific to the individual raising the challenge and says, look, as this particular law is applied to my particular circumstances, it is unconstitutional and unenforceable, and that is what happened here. So, which one did the court choose?
So this is an as-applied challenge. So we have a gentleman here.
And I want to point out also that the court specifically rejected the facial challenge.
Yes. So we have a very narrow decision here, which applies only to Tamari Morgan. So Morgan had, I think, two machine guns.
He did. He had a modern machine gun. He had a newish machine gun, but then he also had the most controversial machine gun part to come along in decades.
Yes.
And that is the
Glock switch.
The Glock switch.
So I can't tell you, when I stand in court in Harris County, Texas, and I hear probable cause, how many probable cause statements have the presence of a Glock switch.
Apparently they're everywhere.
They're everywhere.
They're everywhere.
And if it's
And even though a Glock switch in and of itself cannot fire a bullet, in fact, it's not even big enough to hold a bullet. So even though the Glock switch itself, clearly not a firearm, under the definition of machine gun, that little thing is in fact a full-blown machine gun.
It is. Although weirdly, I will say, I hear it in the probable cause statement, I don't see it prosecuted. They're just like,
he had them.
This many kilos of methamphetamine and a Glock switch. But he's really there for the drugs. So I don't know. Who knows? What does that tell you? So we have this double possession of machine guns. And this is just a challenge to one guy's criminal prosecution. But it's instructive, and that's why I think we need to talk about it. It's not the grand takedown of the Hughes Amendment. It is not set up for that. It is never going to be that. But the reasoning, I think, will largely remain the same because we're undergoing a Bruin analysis. So we're taking a look at, are machine guns arms and thus protected by the Second Amendment? And the answer to that is a resounding
Yes.
yes, they are. And so then we go and we look at, is this law supported by history and tradition? Is there not a historical twin, but a historical cousin to this idea that you can regulate machine guns after, not all machine guns, right? We're not talking about removing them from the NFA entirely, but can you regulate new machine guns when the ones that were not registered after May 19th of 1986? And the government goes through, first of all, they call the prospect of making the Hughes Amendment unconstitutional startles them,
Yes.
shocks the conscience, but then they jump through their hoops for their historical analogs. Did any jump out at you?
Yeah, and they talk about whether or not, of course, the arm is a dangerous and unusual weapon. So, is this machine gun a dangerous and unusual weapon, such that it would lend itself to being regulated by the federal government? And they determine no, it's not dangerous and unusual, and it does go so far as to talk about the fact that there is a distinction between possessing and carrying. And in this case, this individual was only prosecuted for possessing,
Right.
not carrying, possessing the firearm. And so they're like, look, if it's possession, it's just possession. What's the harm in possessing?
I was surprised that there are 750,000 machine guns in circulation in the United States. That is not a number I was familiar with.
Did you think there would be more or less?
I thought there would be less.
I thought there would be more.
Really?
Yes.
Well, what the hell do I know?
Well, because you have, from the advent of the machine gun up until 1986,
Right.
which I would have thought. Now, keep in mind, we hear stories every single day of people being in possession of unregistered machine guns. And unfortunately, those stories are always so heartbreaking because the reason that they're unregistered is because somebody found them in grandfather's footlocker that he brought back or he retained from, World War II. He's got his Thompson machine gun that he never registered in that 1 month period in 1968 where he could have, or he brought back a German Smiser and he didn't register it. And so it always seems to involve some really beautiful, historically significant weapon that you have to tell these people, look, this is not going to work out well for you.
It's not going to work out well.
So I would say that probably the registered ones plus the ones that people possess that are unregistered, that probably is over 1 million.
Oh yeah, certainly. So we have some interesting efforts by the government to justify why there is a historical analog to this sort of law. They specifically, I think the historical analog du jour in many of these challenges coming up now are the affray laws. Like the government wants everything to be an affray law.
Yes.
And that's just not, this isn't even a possession crime. This isn't a carry crime. It's a possession crime.
Correct. Do not affray in front of the king's officers.
Correct. So we have no basis in the affray laws here, but then they go all the way back. Did you notice how far back they go? 1328.
Well, yeah, that's whenever the government told you not to affray or terrorize the king's subjects.
Well, this is the 1328 was not even because there are some more modern affray laws. There were some.
Sure, the one that North Carolina of 1824. So here,
but
see?
yeah, we've got a 1328 English
The
statute.
Statute of Northampton.
What does that have to do with America? Riddle me that.
It existed before 1791.
That is just, but we don't care. We don't care what
Also,
happened that
shouldn't
far
there
back.
be a presumptive intolerance of English laws?
I think there was yes.
So
For
it
good
would seem to
reason.
me that the Second Amendment of 1791 was written in specific response to the Statute of Northampton in 1328.
Absolutely. So, I mean, good try, DOJ, I suppose. But the court didn't buy it, which is great. However, does this specific opinion do much for us? And the answer is
Well,
no.
it doesn't do much for us. Keep in mind, it is a trial opinion of a single district court judge, a Trump appointed
Trump.
district court judge. So it will have to be reviewed by the 10th Circuit. Who knows what the 10th Circuit will do?
The 10th
But
Circuit's kind of a
then,
wild card on this sort of stuff.
sure.
Yeah.
And then ultimately taken up by the Supreme Court. But here is the interesting language, of course. Machine guns have been in existence for well over a century. While the federal government has regulated transfer and possession of such weapons since the passage of the National Firearms Act in 1934, it did not outright prohibit possession of machine guns until passage of the Firearm Owners Protection Act of 1986. And so what they're talking about there is the fact that up until 1986, you if you were found in possession of a machine gun, it wasn't the fact that you were actually having this machine gun, it was the fact that you had not registered this machine gun and paid the tax. That's the offense for what you're. But then in 1986, whenever the
Hughes Amendment.
Hughes Amendment came into effect, it actually specifically created a category of machine guns that you were prosecuted for simply because they were machine guns and you had possession of them.
Right.
So it says that even then the law did not prohibit the possession of all machine guns. Rather, Section 922(o) merely prohibits possession of machine guns that were not lawfully possessed as of the date the prohibition went into effect in 96. Thus, I always like it whenever court opinion says thus or therefore, you know you're finally getting to the
Yeah.
actual point that you have to remember. Thus, even today, it is perfectly legal for a person who has not been divested of his firearms rights under some other provision of the law to acquire and possess a machine gun so long as it was lawfully possessed by someone before the relevant date in 1986 and so long as he complies with the National Firearms Act requirements to obtain possession of the weapon. In that sense, machine guns are not unusual.
So it's good. It's good language. We like the court. It's not what we were talking about just a couple days ago on the channel. It's not that case we're waiting for, but I think it's a good step forward. And I think we have to close because I have to ask you, as a collector, do you have mixed feelings about the Hughes Amendment coming down if it were to do so?
No, I mean,
Would
because
it not devalue collections?
it would devalue collections, but it wouldn't devalue my collections because I don't have any pre-86 machine guns.
Only post 86.
Only post 86 buried in my backyard. But no, if in fact the Hughes Amendment comes down, I am already saving up my money to get me an H&K MP5.
Love it. All right. Well, we hope that you enjoyed this discussion. If you did, consider subscribing, hitting the like button, and help us fight the anti-2A algorithm by sharing this video. And let us know, what would you do if the Hughes Amendment were thrown out by the Supreme Court? Until next time, we're the Arms Attorneys.